So friends, Hunter Biden was just hit with a 9-count federal indictment, including multiple felony counts, after prosecutors had previously agreed to let him plead guilty to just 2 misdemeanor counts. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, I want to talk about the new Hunter Biden indictment because something doesn't sit well with me. Something does not feel right to this old prosecutor. Let's start with the new reporting. This from NPR. Headline, Hunter Biden is indicted on federal tax charges. And that article begins, the Special Counsel investigating Hunter Biden, the president's son, charged him on 9 counts related to his failure to pay federal taxes on millions of dollars of income. A federal grand jury in the Central District of California returned the indictment, charging Hunter Biden with 3 felony tax offenses and 6 misdemeanor tax offenses. The charges stem from Special Counsel David Weiss's long-running investigation into the president's son. If convicted, Hunter Biden faces a maximum penalty of 17 years in prison, though actual sentences for federal crimes are typically less than the maximum penalties. Thursday's development comes months after a plea deal with prosecutors, a plea deal in which the president's son agreed to plead guilty to 2 misdemeanor offenses related to his filing of federal income taxes, fell apart. And so after that attempted guilty plea fell apart, Hunter Biden subsequently pleaded not guilty to the 2 misdemeanor offenses related to his filing of federal income taxes. So friends, let's recap. After years of investigating Hunter Biden, the U.S. Attorney in Delaware decided that an appropriate resolution of the case was to let Hunter Biden plead guilty to 2 misdemeanor tax crimes for which he would have received probation. And Hunter Biden went into court, pleaded guilty, and during the plea hearing, things sort of fell apart through no fault of Hunter Biden's based on the reporting. And so ultimately Hunter Biden entered not guilty pleas to those 2 misdemeanor tax charges, and then the prosecutors upped the criminal ante and just hit Hunter Biden with a 9-count federal indictment. So his exposure went from essentially probation, and now he's facing up to 17 years in federal prison. So let's start with some basic propositions. Not surprisingly, I take the position as a former career prosecutor that if you violate the federal law, you should be held accountable. You should be prosecuted. That includes if you violate the tax laws of the United States. Let me also add that most people, when they violate our nation's tax laws, are not prosecuted. Unfortunately, we have millions of tax cheats, and very few of them are criminally charged. Here is how those cases ordinarily resolve themselves. Once they're caught cheating on their taxes, criminally so, people are generally made to pay their back taxes. They are assessed fines and penalties. They have to pay interest, but they are not criminally prosecuted. Frankly, we don't have the resources in the federal government, in the Department of Justice, to prosecute all of the tax cheats, so relatively few of them end up being prosecuted. That's not to say they shouldn't be. The reality is they're not. But I start from the general proposition that if you violate our nation's tax laws, particularly felony tax laws, you should be held accountable up to and including prosecution. But here's my fundamental problem with how the Hunter Biden case is playing out. So as a prosecutor, when I'm looking at a case, I have to assess the damage that was done to the people of the United States by the tax cheat violating our nation's tax laws. How much harm was done to the people of the United States? And then, as a prosecutor, you have to make a common sense assessment. What is the right plea offer to extend to somebody to address the violations of law, to address the harm to the American people as a result of somebody committing tax crimes? Well, the prosecutor, the U.S. attorney in Delaware, who started out as the U.S. attorney, was subsequently made special counsel by Merrick Garland, so he is continuing in his investigation and prosecution of Hunter Biden, made that assessment. And he assessed that given the crimes Hunter Biden committed, given the damage he did by violating our nation's tax laws, he should plead guilty to 2 misdemeanor tax crimes. And he extended that offer to Hunter Biden, and Hunter Biden, together with his lawyers, accepted that offer, went into court, and pleaded guilty just as the prosecutors had proposed. And then, for some reasons beyond the scope of this video, the plea kind of fell apart when the judge asked some questions that weren't fully anticipated or vetted by the parties, the prosecutors and the defense attorneys, and the guilty plea fell apart. So the fact that the guilty plea fell apart was not the fault of Hunter Biden. And after the guilty plea fell apart, we now see that the prosecutors came back, now Special Counsel David Weiss, and hit Hunter Biden with a 9-count federal indictment, including multiple felonies, exposing Hunter Biden to up to 17 years in prison, when the prosecutor had assessed originally that 2 misdemeanors and a sentence to probation was an appropriate resolution. Can you see the disconnect between those 2 resolutions, those 2 ways to proceed in the Hunter Biden tax case? Probation versus 17 years, up to 17 years in prison. He won't get 17, but that's the maximum penalty that could be imposed as a result of the 9 counts that have been brought in this new indictment. Something doesn't sit right with me there. Let me use not just a hypothetical, but a real world example that I contended with many, many, many times as a career federal prosecutor. For 22 of my 30 years as a prosecutor, I was involved in prosecuting murder cases in Washington, D.C. at the D.C. U.S. Attorney's Office. Some of the murder cases were standalone murder cases in Superior Court, local court, where the federal prosecutors also handle all of the prosecutions. Some of them were murder-driven RICO cases in federal court, but I handled lots of murder cases. And in each and every one I handled or supervised as chief of the homicide section at the D.C. U.S. Attorney's Office, we had to make an assessment. What's the right plea offer to extend in a given case? And here is how we would approach that question. Let's just, and it's a little bit of mixing apples and oranges. I appreciate that when you're talking about murder and violent crime cases versus violation of our nation's tax laws, but the same principles hold true. Let's assume that we had what we believed was a first-degree murder case. That is, an intentional murder committed after premeditation and deliberation. That's a first-degree murder. We might assess that an appropriate plea offer, given the harm that was done, somebody's life was taken, and after consultation with the victim's family to make sure they were comfortable with the plea offer we were thinking about extending to the defendant, we might make the decision that a second-degree murder plea offer was an appropriate plea offer given the harm that was caused by the defendant. If you're interested, the difference between first-degree murder and second-degree murder in the District of Columbia, first-degree murder is an intentional killing after premeditation and deliberation. Premeditation is simply forming a design in your mind to kill, making a decision. That is the premeditation piece. Making a decision to take a human life. Deliberation is turning that decision over in your mind, giving it a second thought, and reaching a definitive determination, yes, I'm going to do it. No amount of time needs to pass between the premeditation and the deliberation, but you have to prove beyond a reasonable doubt that the killing was intentional, it was after premeditation and after deliberation, in order for it to be a first-degree premeditated murder under the laws of the District of Columbia. Second-degree murder, however, is simply an intentional killing. No need for premeditation, no need to prove deliberation. It could be a spur-of-the-moment intentional killing. So we might assess that, thank you for bearing with me through that quick Team Justice Law School class. I do miss the courtroom. So we might assess that a second-degree murder plea is appropriate. You know what I never did assess in a murder case? That a guilty plea offer to simple assault was appropriate, right? A simple assault, like a unlawful shoving of somebody, right? Technically that's a battery, but let's just call it a simple assault. I would not assess that to address the harm done by the defendant, a simple assault plea offer, probation eligible plea offer, was appropriate. Why? Because it's not appropriate if the offense involves the taking of a life of a fellow human being. But now, when you apply those sort of general principles to the Hunter Biden case, if the prosecutors assessed that to address the harm involved in the crimes committed, the tax crimes committed by Hunter Biden, 2 misdemeanors and a probation sentence was appropriate to address the harm, how is it that when that plea deal broke down through no fault of Hunter Biden's, he went into court and pleaded guilty as the prosecutors had asked him to do, how is it that now he gets hit with 9 counts, including multiple felony counts, and is facing 17 years in prison? That is sort of like the chasm between simple assault and first-degree murder or second-degree murder. The chasm between 2 misdemeanor tax crimes and probation versus 9 counts, including multiple felonies and up to 17 years in prison? Friends, I can't say where, I can't say how, but somewhere along the line in the Hunter Biden investigation and prosecution, somebody took their eye off the justice ball. And justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.